Good afternoon, everyone. I am John Baldivia, partner at Rossi PC, and I'm the chair of the Entertainment Law section of the Beverly Hills Bar Association. We're looking forward to having you today for this timely discussion. I'd like to introduce the speakers, all of whom have experience that's heavily relevant to the Dominion versus Fox litigation. First, starting with Doug Mirell, who is a powerhouse litigator at Greenberg, Glusker, and who represents celebrities, companies, guilds, media concerns, and others. Specifically, Doug is a leading force in First Amendment and entertainment industry lawsuits, anti-SLAPP motions, copyright and trademark infringement actions, new and traditional media law issues, invasion of privacy and defamation claims, and publicity rights disputes. Doug has been named a best lawyer in First Amendment litigation by Best Lawyers in America for more than a decade, and was Best Lawyer Southern California Lawyer of the Year in First Amendment litigation twice. Next, we have Catherine Ross, who is the Lyle T. Alverson Professor of Law at George Washington University Law School in DC. She specializes in constitutional law with particular emphasis on the First Amendment and family law. Professor Ross's book, A Right to Lie, Presidents, Other Liars, and the First Amendment, was published in November 2021 and has been featured at events at the Cato Institute, the National Constitution Center, and other venues. Prior to entering legal academia, Professor Ross was a litigator at Paul Weiss in New York, so she has a practitioner's perspective as well. She holds her BA, PhD in history, and JD from Yale University. Also on our panel, we have Alexander Rufus-Isaacs, who we lovingly refer to as Zan, who is an Oxford University graduate who began his career as a barrister in England and has practiced in Los Angeles for more than 30 years. He is a litigator with an emphasis on media, entertainment, and business disputes. Zan has a particular focus on plaintiffs' defamation cases and jokes that these days he watches Netflix at night and sues them by day. But he has also represented defendants, including as California counsel for News Group Publishers of the Sun, in its successful defense of a libel action brought in the High Court in London by Johnny Depp. Zan is president of the Beverly Hills Bar Association, has been selected annually as a super lawyer since 2017 by the Southern California Super Lawyer magazine, is LA's Lawyer of the Year for copyright in 2023 by Best Lawyers, and has been honored as a media litigator by numerous international law and business organizations. Last but not least, we have our moderator, Karen Grant-Selma, who is the principal of Selma Law Group. Prior to private practice, Karen was a senior VP of Business and Legal Affairs, overseeing all business affairs and legal matters at OWN, the Oprah Winfrey Network. Her career with business and legal affairs for entertainment companies spans over 20 years, including at DreamWorks Animation, ITV Studios America, Live Nation Productions, Universal, and more. Karen, I am happy to turn things over to you now.
Great, thank you so much, John. And thank you to everyone joining us this afternoon. Let's dive right in. So this past week, Dominion and Fox News settled their action for defamation in what was expected to be the First Amendment trial of the century. We will discuss the claims and the settlement in more detail, but let's just start out with how this lawsuit came to be before we opine on the surprising finale of this multi-year drama. So, following the 2020 presidential election, suggestions of potential voter fraud turned into downright accusations and conspiracy theories that Dominion had rigged the election by using software in their machines that would automatically flip a certain number of votes from Donald Trump to Joe Biden. Fox executives and on-air personalities allowed multiple guests, including Rudy Giuliani and Trump attorney Sidney Powell, to appear on various programs to vehemently make these claims, but with no evidence to support them. All the while, Fox News was receiving fact-checked reports that wholly debunked these claims from not just Dominion, but also the Associated Press and Trump's own Cybersecurity and Information Safety Agency. Backed by thousands of pages of text messages and emails exchanged with Fox executives, Dominion argued that Fox unfairly smeared the company and that they knew such claims were false and allowed them to be broadcast anyway. In its defense, Fox claimed that these allegations were justified because they were newsworthy and that there was no malice in their efforts to share the story with their audience. So, to begin, let's talk about the motions and the defenses. And why don't we start with you, Catherine?
Thank you. Great introduction. So I couldn't agree more with Karen that this was supposed to be the First Amendment trial of the century, because we have not had a trial like this since 1964, New York Times versus Sullivan, which established the modern constitutional standard for defamation cases involving public figures. And for purposes of this litigation, Fox and Dominion agreed that Dominion was a public figure, even though that was not the original Sullivan definition, which involved people who held public office. It's been greatly expanded. And the Fox position was that the First Amendment protects anything they wanted to say anytime because they're journalists. And this, of course, is not what Sullivan said. Sullivan said that when we have a First Amendment claim and a public figure, the standard puts a constitutional layer of protection over the normal common law defamation claim, in which the plaintiff only has to show that the statement was false and harmed their reputation or their business. And where there's a public figure, the court framed a new test referred to as actual malice. And you're lawyers in this audience, so you may know, but I want to make clear, actual malice doesn't mean in the Sullivan context what you and I mean when we're gossiping about people we know. It means that the speaker and the publisher either actually knew the statement was false, or they had sufficient reason to know that if they proceeded, they behaved with reckless disregard of the truth or falsehood. And that is the hurdle that is very, very hard for plaintiffs to establish. And in fact, it is virtually never shown. And that's why we see fewer and fewer serious defamation cases about news media and public figures. What made this case so important and so highly scrutinized were two things. And the first was the absolutely extraordinary facts about the number of falsehoods, the repetition of falsehoods, and the very bright lines that were either approached as close as possible or clearly crossed. And then we had discovery. Dominion had discovery. And the discovery showed astounding things, a written trail, what I like to call Hansel and Gretel put down all their breadcrumbs and nobody ate them and anyone could follow them. So we had this enormous number of emails and text messages and recordings and testimony and depositions that showed, one, that a lot of the speakers and the higher ups at Fox, who are the publishers, actually knew what they said was false and didn't believe what they were saying, and in fact held diametrically opposed personal views of the characters and of what had happened. And if they didn't really know it was false, they had more than enough reason to be on notice that it might be false and they'd better check. One was their internal fact checkers, Karen referred to, kept telling them, this is garbage. You can't say this. And they basically said, we don't want to hear this. Go away, which is pretty amazing. Their lawyers apparently didn't intervene or didn't intervene in a way that got any attention. So we had numerous shows, we had higher ups, we had depositions by people, including Rupert Murdoch, who admitted that it was false and he could have stopped it at any time, but he didn't. He said amazing things in his deposition. Okay, so that's what made it extraordinary. And that's what made many of us hope that this could tell us for the first time in more than 50 years what actual malice looks like. And so we would be able to say, here's a bright line that you can't cross if you're the media, but we're not worried some people were, but I wasn't, we're not that worried that a lot of people will feel chilled, speakers will feel chilled or be swept up in this new net of actual malice, because it is so difficult to look anything like this case. This case is too extreme. It's a great borderline that people can understand, and it will give guidance moving forward. And especially as we move forward to the next election cycle, although that wasn't the most important thing. But the judge, prior to the settlement, decided two important motions: a motion to dismiss, which he said was basically completely meritless, and cross motions for summary judgment, in which he concluded that there were very few factual, if any, factual disputes. And so he resolved all of the First Amendment claims, except whether the actual malice standard was left, which he left to, was met, which he left to the jury. But all of Fox's First Amendment defenses were demolished totally, completely in the judge's summary judgment opinion. And so one of the concerns is, of course, this is a Delaware Chancery Court judge. Had the jury reached a verdict, it was highly likely that this would have gone up on appeal and quite likely have made it to the Supreme Court, but certainly to the circuit courts, which would have clarified whether the trial court judge got the First Amendment law right. And now we only have a trial court's decision. But I think it was a spectacularly well-crafted decision. And I think he was right on every point. So let me tell you what he said about Fox's First Amendment defenses. First, no, as even Justice Black, the foremost First Amendment absolutist, said repeatedly, free speech doesn't mean you can say anything you want at any time. And one of the obvious categorical exceptions is common law defamation. You can't lie about people and demolish their reputation and their business. But then Fox came up sort of like, dancing around with a bunch of subcategories. One was, well, these were just opinions. And the judge said, no, under First Amendment law, an opinion is where people agree on facts that are verifiable, and then they may disagree about what the facts mean, but you were lying about the underlying facts. He had gone through each of the 20 incidents that Dominion put at the heart of their complaint, and he found that in each of these incidents, the Fox had spread falsehoods, that these were clear, in capital, falsehoods. There was no question for the jury about what was true and false. Then Fox said, we were just reporting things that were newsworthy because people said something and we thought the audience should hear it. No, the judge said, you didn't just report it. First of all, you made editorial choices about who to invite on your show. And then you let them speak without context, without challenging them. And in a number of instances, the hosts actually echoed. So, for example, Maria Bartiromo said, we know there are election lies. Tell us more about it. That is not simply reporting that somebody said something. And when the hosts asked for evidence behind the scenes, they were told, we have none. And then they went ahead and put it on air anyway. So not opinion. Then Fox said, not opinion, not just reporting newsworthy events, because there's no framing. Then Fox said, well, there are a couple of privileges here. And some of them are a little esoteric. But they said, for example, we were reporting on a proceeding. Well, first of all, that's about reports about a pending court proceeding. There was no court proceeding. They weren't talking about it. And it is not a privilege that is recognized under New York law. And even though the case was in Delaware, it was applying New York law. So it was a pretty specious defense to start with. then there were a couple of other, similar tweaks on that. And basically the court said, there is no First Amendment defense. Your only option is to convince the jury that Dominion hasn't showed actual malice. So that's a form of First Amendment defense, but it's not the core free speech defense that Fox was posturing about. And so after that, they had really almost nothing to pin their hats on, except for, especially given the discovery trail. How were they going to show no malice when there was this written a cornucopia of proof that they knew or had proceeded with reckless disregard? So these are all issues that would have been very helpful to have clarified, and especially the question of what does it take to meet the actual malice standard. And so we're going to be waiting possibly a very long time for the resolution of those issues.
Wonderful. Thank you, Catherine. So with that in mind, we'll move along to the motion for summary judgment. And Zan, why don't you talk to us about that and the significance of the malice issue?
Thank you, Karen, and thank you, Catherine. That was really interesting. I think one of the key takeaways from this case is the fact that after considering the briefs for 4 months, Judge Davis denied the motion to dismiss. What he did as a result of that was he allowed Dominion to take discovery. And a lot of us practitioners, when we're dealing with defamation actions against public figures, there are certain pleading requirements that you have to satisfy, that there be a clear and convincing evidence of actual malice. And it's very difficult sometimes to come up with a plausible set of facts showing clearly and convincingly that the defendant knew that they were peddling falsehoods or were being utterly reckless until you've done that discovery. And Judge Davis allowed Dominion to go forwards, and Dominion found the treasure trove. And I would expect any plaintiff's side lawyer arguing a motion to dismiss to a judge who's having questions or reservations as to whether or not the complaint has satisfied the pleading standard, particularly in federal court under a couple of cases called Iqbal and Tomley, of going, Your Honor, think of Dominion. Before Dominion was entitled, was able to do discovery, the only evidence it had of actual malice were the messages, 3,600 of them may be, sent by Dominion and its general counsel to Fox, correcting all of the errors that Fox was making as it was peddling these election lies over several months. And that in and of itself, you would hope would be enough to get over the burden. And then on top of that, you have Attorney General Barr saying that there'd been a finding that there was no election fraud. So, I think on that basis, that's why Judge Davis allowed it to go forwards. But then once Dominion got hold of this treasure trove of internal emails and texts showing all the debates that were going on inside of Fox, this is when the dynamic absolutely and totally changed. And I'm going to delve into the summary judgment motion in a little bit more detail, though, for those non-lawyers out there, and I know some of you are out there, a motion for summary judgment is a motion that either side can file, but it's normally filed by the defendants. And what these motions ask the judge to decide is either the outcome of the whole case or important parts of it. And it's on the grounds that the parties agree about the material facts, and therefore there's no need for a jury to figure out and decide whether the light was green or the light was red. But normally, if the motion is going to be denied, there's most often denied on the basis the judge says there's an issue, tribal issue of disputed fact here. We're going to need a jury to figure that out. And I think in this case, again, like I was saying, what's fascinating, what Catherine touched on, was all this evidence of the knowledge of the Fox executives and hosts that, these theories that were being peddled were completely false. There were basically three motions for summary judgment, one by Fox News, one by Fox Corp, and one by Dominion, all seeking determinations. Dealing with the Fox News motion first, they were seeking basically to have the case against them thrown out. And as Judge Davis looked at it, he saw two main arguments. He said, firstly, they're arguing that merely reporting allegations of voter fraud is inherently newsworthy, and as Catherine mentioned, subject to privileges which are debatable, certainly under New York law. And secondly, they're saying that any statements that the hosts made about the election fraud, they constitute expressions of opinion which are protected by the First Amendment rather than statements of fact which are actionable. And Judge Davis rejected these arguments in part because they're so contradictory. And I really like what he said in one sentence of his ruling, where he says it appears oxymoronic to call the statements opinions while also asserting the statements are newsworthy allegations and or substantially accurate reports of official proceedings. It's inherently contradictory, and I think it's an example of the danger of pleading alternate theories that are inconsistent. Fox Corp, which is the parent company, they adopted Fox News arguments and rode their coattails, but they also argue that neither Rupert Murdoch or Acland or any of its other executives had any direct role in creating or publishing the defamatory statements, and therefore they moved for summary judgment on the basis that they weren't responsible for Fox News's activities. And there's a considerable amount of evidence that came out during discovery that showed that Rupert and Acland were both involved in editorial decisions. They attend editorial meetings. And of course, they have the ultimate power to make changes. I mean, for example, I think Catherine mentioned or alluded to it when asked by the Dominion lawyers in deposition whether he could have done more to stop his network from peddling the Powell and Giuliani election lies. Rupert Murdoch memorably said, "I could have, but I didn't." And it was discovered late in the day that he was actually an officer of Fox News. But in any event, Judge Davis found there's tribal issues of fact as to whether or not Fox Corp, the parent company, was liable for publishing it. And so that's an issue that would have gone to trial. Moving on to Dominion's motion for summary judgment against Fox News. Dominion basically came up in the lawsuit is about the 20 particular defamatory statements. It's my understanding that they originally had a list of about 100 defamatory statements made over these several months, and they winnowed them down to about 20. And all of these statements were statements by the Fox hosts endorsing the falsities that their guests were uttering. And so it was they were actively endorsing it. They weren't just putting the Sidney Powell and Rudy Giuliani on and letting them opine. They were actually agreeing with what they were saying. And also, I think 19 out of 20 were statements were made after the multiple messages from Dominion were sent to Fox correcting the record. But in any event, of these 20 defamatory statements, and another interesting issue with them is that 18 of the 20 were made by what one might consider to be second-tier Fox hosts, no disrespect, to Lou Dobbs, who's already left, Janine Pirro, and Maria Bartiromo. And there were only two, one by Sean Hannity and one by Tucker Carlson. So it shows which of the hosts are more skillful at avoiding the more obvious sort of traps from a defamation point of view. Dominion basically categorized these 20 defamatory statements into 4 sections. There was a fraud lie, an algorithms lie, the Venezuela lie, and the kickback lie. And they moved for summary judgment on the basis that each of these categories of statements was firstly false, secondly, that they were of and concerning Dominion, thirdly, that they were published by the Fox entities, fourthly, that they're defamatory per se, and fifthly, that they were made with actual malice. Judge Davis says, yes, there's certainly these statements of and concerning Dominion. They were certainly published by Fox News, not Fox Corp. He didn't find that, and that they were defamatory per se. So the two big issues he left were falsity and actual malice. So on falsity, he granted the motion. He granted Dominion's motion. He said, and it's ringing tones, quotes, "The evidence developed in this civil proceeding is," capitalized, "crystal clear," end cap, "that none of the statements relating to Dominion about the 2020 election are true." And that is as clear and straightforward as you can get, and it represents a huge win for Dominion. It's this where the alternative reality of stolen elections sinks like a stone when it's subjected to legal examination by an impartial judge, based on evidentiary rules that are designed to elicit the truth. On actual malice, it's rare for a defamation plaintiff to file a summary judgment motion on this issue because it's so hard to win. It can only be granted if there's no dispute as to the defendant's state of mind, and it being subjective, it's almost always the defendants are able to raise some dispute of fact. This case, as Catherine mentioned, represents an unusual situation because of the amount of discovery and the amount of evidence we have of their knowledge, and the fact they knew these allegations were not only wrong, but crazy, absurd, and shockingly reckless. And Fox did so not just once, but continually for months. In his defense, Fox argued that some of its hosts did believe that the statements they made about the election being stolen, they actually did believe them, or at least they said there's a big difference between being unsure as to whether something was true as opposed to being certain that it was false. And they're also arguing that you can't have a determination of actual malice if you're relying on statements made by elected officials. And it also argued that the executives who had made the comments about the not believing the statements to be true, that they hadn't actually had control over the actual scripts that contain the defamatory statements. So Judge Davis, to conclude, found that there were multiple disputed issues of triable fact and denied both sides' motions on actual malice. And so the trial would have gone forward, the case would have gone forward to trial on the issue of actual malice and on damages.
Karen, can I just respond to two things that Sam said? I don't want to tap into Doug's time, but one is that about the Fox Corporation, there were a flurry of discoveries in the days just leading up to the trial after the summary judgment motion, where it became apparent that Fox had not fully complied with the discovery rules and had withheld information. And one of the pieces of information was that, in fact, Rupert Murdoch held a chairmanship title at Fox News. And therefore, the judge was very angry. It was clear he was very angry. He ultimately referred questions about discovery and being forthcoming to a special master. But it seemed quite likely that he might decide to reopen the portion of the summary judgment opinion. It seemed to me that it would be very much in his power and that it would behoove him to say, now that we know that Rupert held a major leadership position at Fox News, this should not be a jury question about whether Fox Corp was responsible as publisher. And I'm going to take that away from the jury because he indicated that discovery should be reopened in all likelihood so they could ask questions they were barred from asking before they realized what Murdoch's role in Fox News was. So I think that is an important thing, and also a very important lesson about failing to be forthcoming in discovery. And he also reserved the right, he said, after trial, I may have additional things to say, either in an opinion or in instructions to the jury, bearing on the other issues that I'm sending to the jury. So it wasn't the final word, and it's a little bit similar to what your very good point about the importance of holding off on the motion to dismiss while discovery was ongoing. And he said, even though there's been discovery, I haven't heard the presentations. There may be more information that bears on the legal questions in this case.
Great, thank you, Catherine. So Doug, what do we know about the settlement? How did we get to this point?
So, well, as we do know, the case did not proceed to trial and it did settle. And from Fox's point of view, in my opinion, they had to settle. It was necessary, indeed, maybe imperative that they do so. And from Dominion's perspective, I think it was valuable and prudent. But let's talk about, those are sort of the bottom line results, but let's talk about why Fox might have settled this case. Dominion was seeking $1.6 billion in compensatory damages. And a verdict could well have been over $1 billion if the Delaware jury of 6 men and 6 women, 7 of whom were Black, had awarded significant punitive damages. Now, how much of the $787.5 million will Fox actually be paying? Well, by making the parent Fox Corp a defendant, that entity's wraparound umbrella insurance was likely triggered, providing substantially more coverage than a typical errors and omissions insurance policy would. And by avoiding any actual malice determination by a jury, Fox will now be able to argue that its false statements were merely negligent, thus depriving Fox's carriers of the argument that this is an uninsured intentional tort. Moreover, had Fox gone to trial and been hit with punitive damages, none of that would have been insurable either. And indeed, though I'm no tax expert, news reports have suggested that this settlement will allow Fox to take a significant tax write-off, perhaps as much as $213 million of the 787. Yet, even if these assumptions about insurance coverage or tax treatment aren't accurate, we have to remember that Fox Corp reportedly held $4 billion in cash or cash equivalents as of February 2023, and that Fox News alone reported $2.9 billion in pro forma earnings in 2022. So the true lesson I take away from this actually comes from Love Story. Paying $787.5 million means never having to say you're sorry. And because Dominion declined to insist that Fox issue any retraction, correction, or apology, I think that that's a true characterization. And Fox's audience, let's remember, is no wiser. Following the settlement, the Fox News website made no mention of it. And in the first 4 hours after the settlement was announced, it ran only 3 stories, totaling 6 minutes of airtime in those 4 hours. And that, in fact, serves to preserve Fox's lying to our audience business model, as Professor Lawrence Tribe has characterized it. It helps stave off the threats that are posed by Newsmax and One America Network News to Fox's business and to the potential poaching of its viewers. And the press statement that ultimately Fox did issue was never posted on the Fox News website. And for reasons we can discuss later, it was worse than nothing. So we'll apparently, as a result of this settlement, never learn the contents of the roughly 82 often lengthy excerpts that were redacted from Dominion's publicly filed 130-page summary judgment brief. And we'll also never hear trial testimony by the 92-year-old Rupert, who has, as my colleagues have already pointed out, already said that Fox's hosts endorsed this mendacity. Fox will also avoid 5 to 6 weeks of testimony that would have only poured salt in the wounds of its hosts, whose text and email messages are already exceedingly damaging. And finally, and perhaps most important, it avoids an actual malice finding that could make bad law, which would be problematic in general, but problematic in particular for Fox in its other defamation cases, most immediately the $2.7 billion defamation lawsuit by Smartmatic, another election technology company that's now scheduled to go to trial in 2025. So let's turn briefly to why this was valuable and prudent for Dominion. Why did they settle? Well, $787.5 million is a lot of money. And they get a wire transfer now rather than awaiting a jury verdict and years-long appeals. And according to their lawyer, who held a press conference outside the courthouse, money is accountability, and maybe he's right. But certainly they get bragging rights to perhaps the largest defamation settlement in history. and certainly the largest reported defamation settlement by a media defendant. But who's the biggest winner in this? Well, I would argue it's State Street Capital. This private equity fund, which holds a 76% ownership stake in Dominion, will receive a 1,442% return on its initial $38.8 million investment that it made in 2018. And another reason why I think Dominion settled is that in Delaware and New York, there is a unanimous vote requirement for liability and damages. That contrasts with what we have here in California, which is a 3/4 vote requirement for state court civil jury verdicts. And a unanimous vote requirement increases the risk of a rogue or holdout juror that might have undermined Dominion's liability and or damages posture. Dominion already got out of Fox's leaders, as we pointed out previously, and from its hosts, what it wanted by way of actual malice evidence in its document discovery and its depositions. And it may, as Zan has pointed out, have been concerned about satisfying the clear and convincing evidence hurdle that it would have had to surmount. If Dominion had lost a trial, it might have jeopardized the outcome of its 5 forthcoming trials against Newsmax, One America News, Mike Lindell and his My Pillow Company, Rudy Giuliani, and Sidney Powell. And of course, a fear of an appellate reversal of a favorable jury verdict which could have resulted in significantly reduced damages, or could have created bad law that would likewise have adversely impacted these same 5 future cases. So finally, by resolving this case now, I think there's a chance that Dominion can point to this settlement as a confession of guilt that it can use to try to convince other jurisdictions to actually purchase its voting machines and to actually trust that their output will be reliable. I suspect that argument will be accepted in blue jurisdictions. Whether it will be in red jurisdictions remains to be seen.
Thanks, Doug. So a question for the 3 of you. What do you think the implications of this will be going forward for the public, for news, media, etc.? Zan.
One question I would love to know, but I'm never going to know the answer, is what sort of discussions were going on behind closed doors at Fox before Dominion actually filed the lawsuit. Were the editorial department being told by the in-house lawyers that they are treading on very dangerous ground and that they are in danger of, being sued? But in any event, even if they were, the editorial department won out on this. And I am wondering if when there are going to be in-house discussions in all sorts of media corporations in the future, if this result is not going to give the in-house lawyers tremendous leverage, because they're going to use that mantra every time there's a discussion about whether or not we go up to or over the line as to what we think is safe, it's going to be remember Dominion. And I'm hoping that from a cultural point of view, giving the lawyers, with a degree of, shall we say, of prudence in these situations will hopefully inject some sensibility. And that's the first thing I would like to say.
Having worked in-house at a network, I would have loved to be able to say, remember Dominion. But
I think the other thing I'd like to say is this, and I'm following on from what Doug said, is absolutely. I think my take on it is that Dominion were concerned in the lead up to trial that even if they won, they might not win big. There was the report is that there was 15 million was the value of the contracts that were not going to be renewed as a result of the statements. And there were causation issues. And it's possible that they would have won, but only won a little. And if that had happened, Fox would have trumpeted this as a big win. And now that Dominion has this incredible war chest, my hope is that they are going to use that and they are going to take these other 4 cases the whole way, so that what we have been deprived of in the Fox case, namely, the executives and the hosts being grilled in unfavorable courtroom lighting about all these various untruths that they were peddling, my hope is that we are going to see those scenarios being played out in those other lawsuits. The other thing I want to say is this: I think it's amazing that this case went to trial so quickly and forced its settlement in less than 2 years, whereas Smartmatic was actually filed in New York before Dominion, and yet in Smartmatic, they've got a 2025 trial date. So big argument for, in favor of Delaware.
Any thoughts from you, Catherine or Doug, on the future implications?
I'm a little bit more skeptical about, and I'm not in practice anymore, so I defer to those of you who are dealing with these clients all the time. But, a lot of corporations regard lawyers as the people who get in the way, regardless of what the business is involved in, that the lawyers are, slow stepping, and they're always saying no and trying to make problems. And we just want to move forward and we want to get the deal done or get the show on the air. And so I think that if we have a period when this is top of mind, that would be helpful, and maybe we could have some education and some cultural change. But I'm skeptical that would be a long-term change in organizational strategy and culture, and especially, as Doug said, for a company whose business model is lie, because then they don't have an audience. This is clearly what was driving them from the discovery documents. If we don't lie to our audience, they will desert us. We have to give them what they want, which is these conspiracy theories. I think it would be great if the lawyers ultimately were able to create some cultural change, but I have a wait and see view of that.
And I would just add that,
with all respect, Zed.
So,
and I would just, not the way I say it to a judge, which is like, all due respect. I really mean respect you.
I would just add that the Murdoch empire has suffered, significantly greater losses before. As a result of the phone hacking and bribery and influence peddling scandal in the UK, they had to pay out a reported at least $800 million in order to resolve that case. So, they've got the resources to withstand this. And I, too, I guess, count me skeptical, along with Catherine, whether this is actually going to result in any affirmative change, even after the dismissal yesterday of Tucker Carlson.
If I could add, yes, what Catherine was saying about it won't alter the internal culture, but I can guarantee you one thing, that there are going to be legions of aggressive plaintiff lawyers up and down the country, all looking for their Dominion versus Fox, that these networks are going to be scrutinized. And I can see this as being there being many sort of copycat type lawsuits as a result of this, after Dominion has shown the way. And if anything is going to keep these folks honest, it's going to be the plaintiff's bar.
Well, and just a cautionary note there, that may be true in jurisdictions that don't have robust anti-SLAPP statutes. And, those are statutes which, topic for another day, but generally serve as significant impediments to getting the kind of discovery that that Dominion was able to extract out of Fox, and requiring that essentially you prove your case as a prima facie matter at the outset. And that, had a statute like that been at play in this case, it might not have gotten very far.
Yeah, Delaware doesn't have a SLAPP statute. Mm-hmm. No coincidence that that's where this lawsuit was filed.
Surprise, surprise. So looking at some of the questions we've received from the audience, I think we'll jump into a couple of them. So one anonymous attendee asks, do you think an apology was discussed? Why didn't Dominion demand one, or Fox mea culpa?
I think it traded an apology for money. I think that a significant component of the amount that was actually agreed upon was attributable to Fox's not having to prostrate itself and to offer up either a retraction or a correction or an apology. And I would simply note that that's pretty de rigueur in cases like this. Melania Trump succeeded in suing the UK-based Daily Mail tabloid over a story that it published that when she was in Slovenia, that the modeling agency she worked for was really a front for a prostitution ring. And in that case, not only was there a $2.9 million monetary judgment, but there was also a confession of error and a retraction and a withdrawal and an apology that the Daily Mail published. And the fact that it didn't happen here, I think, speaks to the fact that as Dominion's lawyer said, they viewed money as their means of extracting accountability.
Okay, great. So another attendee asks, will the defendants in the other Dominion lawsuits be able to use the Fox payment as a credit against the alleged damages?
I don't think so, because unless there are statements where both Dominion and Smartmatic are both being defamed, it depends very much on the wording. I think, yes, that's an interesting point if they are both mentioned in the same sentence, but I don't know enough about the Smartmatic lawsuit to say whether they're fully independent of the allegations made against Dominion.
Yeah, I think I too am just speculating here, but I think that that's not going to happen. And the biggest question, I think, will be, to what extent will the discovery that was obtained by Dominion in this case be usable or used by Smartmatic in its case? And beyond that, there's this other lingering lawsuit out there by Abby Grossberg, who was Maria Bartiromo's former producer, who has been able to provide additional documentation, and who I understand has been speaking with Smartmatic's lawyers about what she learned about additional evidence that Dominion didn't initially produce, but that ultimately it was forced to. And she apparently has further recordings that may shed some additional light that may be usable by Smartmatic in their separate trial in 2025.
Okay. Well, another question. Could you discuss Fox newsworthiness defense in a bit more detail? How well accepted is it, and is it recognized in courts in California?
In California specifically, or generally?
Well, more generally the newsworthiness, and then more specifically, is it recognized in California also?
I don't know about California, but I can talk about, more generally. So, there is editorial discretion. And so you pick and choose what stories are worth covering, and you can decide not to cover something a presidential candidate is saying, and you can decide to cover the weird person who's outside the Russian embassy every day and has been there for 20 years and cover what he says. So there are journalistic standards, but they're not a matter of constitutional law. The First Amendment doesn't say you have to follow journalistic standards. And if it did, then we'd have a problem, because somebody in the government would be deciding what does and doesn't satisfy journalistic standards. So newsworthiness, according to Judge Davis's opinion, and I think he's right, has to do also with the framing. So if you say this is newsworthy because the former president, and I emphasize the word former here and not the president, referring to the same person, and his allies are making charges, and we're reporting what their charges are. And we're either telling you that they have not provided us with evidence, or we're saying we have not a clue whether they have a basis for this. That could be described as covering an event because it happened and you think people would be interested. But what Fox did was tell us this really is newsworthy because the underlying statement itself is newsworthy. There was election fraud. Votes were stolen. That is not newsworthiness that is protected by the First Amendment.
And so let me just speak briefly to California. We have a Civil Code section 47, which contains numerous privileges. And among those that Fox sought to invoke against Dominion were what are called the fair and true report privilege, as well as the official proceedings privilege. And as Catherine correctly pointed out, those were rejected by Judge Davis. And I think if the case had been brought in California, a similar result would have applied.
I'd like to add that in the UK now, newsworthiness is a very strong defense. I believe it was introduced by some legislation, I think around 10 years ago. But if you read reports of UK proceedings involving matters of public controversy, it's the media's normally relying very strongly, saying this is a newsworthy item, we're doing our best to report it, and even if we got it wrong, we did so in good faith. I think the recent case involving Ms. Cadwallader, she won on that particular issue. And but again, I just had a quick look and I couldn't see that it's actually been any parts of that in California law, but that's only a quick glance.
But of course, in Great Britain is at one extreme and the US is at a very different extreme in terms of defamatory statements and our concern about either allowing or squelching them in the context of public interest and matters of public concern.
Yeah, it is, but it's like I think the principle is the same about the newsworthiness defense in the UK, and I'd like to talk about this because although I did practice in the UK, I don't practice there anymore. But it's the same principle, which is that if you are and I think it's really aimed at sort of news media, that if they make a good faith statement, even if it turns out to be false, then they're protected if they were operating in good faith. And whereas here, that's enshrined in actual malice, this is where newsworthiness comes in the UK. It's like if somebody publishes something believing it to be an issue of that's worthy of public attention, even if it turns out they get it wrong, that's a defense for them. But you're quite right, it's Catherine, it's a very different landscape.
Okay, next question. We mentioned earlier, or actually Doug, you mentioned the motions that had the multiple redactions. What did you say, 80 plus?
82 excerpts. Some as long as a page of the 130 pages.
Oh my. So one of the questions is, can the press move to unseal the redactions? There's thought that there's precedent that allows this.
I think they can. I think they should, and I hope they do. You know, whether there is anything in the settlement that would impact that, I'm having difficulty figuring out what that conceivably could be. And we don't really know, I believe, Catherine, why it is that those excerpts were redacted in the first place. And so that may be a question that will need to be approached directly by media lawyers with Judge Davis.
Okay,
Karen, if I could interject one thing.
absolutely.
Big picture, I see this settlement as a ringing endorsement of New York Times versus Sullivan, which is under, quite a lot of attack to US Supreme Court justices, Florida legislatures. A lot of people are saying you can't win lawsuits against public figures because of actual malice. This case proves that you can and that it works. And I hope that these moves to repeal New York Times Sullivan, I hope they found I don't know if any of you have been reading. I read an excellent book recently about New York Times against Sullivan and the whole background, and it's quite a fascinating case.
Should share the title of that book. While you look for that, the next question, going back to the lack of anti-SLAPP statute here.
Actual malice.
Malice.
It's sitting here, but I haven't started it. Brand new.
We know you have so much time. Going back to the lack of anti-SLAPP statute at play here, do you think courts in anti-SLAPP jurisdictions will look at the Fox case as a cautionary tale, given that there were plainly valid claims which would have been obscured with the Dominion's discovery?
I guess I would say I hope that that's the case as well. And what I hope too is that in California, there is an exception in terms of the freeze on discovery that comes into play immediately upon the filing of an anti-SLAPP motion. The exception is if you can demonstrate good cause for wanting discovery. And because actual malice is such a fact-intensive and subjective inquiry, I would hope that courts would take away from this the notion that, well, maybe we ought to give some greater leeway to folks who are trying to defend against anti-SLAPP motions by allowing them to conduct actual malice type discovery. And so we'll have to see if that's a potentially valuable fallout from this case.
And if I might add, in federal court, the rule is much laxer, and I think you are entitled to take discovery when there's a SLAPP motion pending. But here's what's interesting about it is that if you do have the right to take this discovery before this initial knockout motion to dismiss is decided, aren't you better off under the federal pleading standards of being facing a SLAPP motion where you do have the option of taking discovery rather than on a motion to dismiss where you don't?
I think that's true. I think that's true.
So that would mean you're almost better off filing in a jurisdiction that does have a SLAPP statute, because it means that you will be able to take that discovery. The downside, obviously, is that the client is then going to be looking at the danger if they lose, that they're going to have a massive award of attorney fees against them. But anyway.
Yeah.
Well, unfortunately, our time is winding down. So just want to ask if you have any final thoughts or takeaways or just some point that you would like to mention that didn't get mentioned earlier. Anyone?
I just think it's very worthwhile to follow the remaining cases that are coming up. Not just Smartmatic, but the remaining Dominion cases. And some of these issues may play out further.
So I guess I would just add that it is interesting to me how Fox's slogans have evolved over the course of time. They started out being the fair and balanced network. They then became the most watched, most trusted network. Then real news, real honest opinion, and most recently, since November of 2020, standing up for what's right. And I leave to the audience and to my fellow panelists what right means in that context.
And I'd just like to say a very good point, Doug. Thank you to everybody, first of all, who's attended today, and certainly to the people who have asked questions in the Q&A. And I'm sorry, there's some good questions there. I'm sorry we weren't able to get to them all.
Right. Well, thank the three of you for participating in this discussion today and sharing your time with the Beverly Hills Bar and our attendees. Doug, Catherine, and Alexander, thank you very much.
Thank you.
You.
Goodbye, everyone.